everyone. Thank you for being here for class number 8 of our 2026 virtual HOA Condo Academy. If you joined our live virtual First Friday event earlier this month, you may have heard Beth Mulcahy mention that she wouldn't be with us today. It's a big week for Beth and her family. She's dropping her daughter off at college in New England. For those of you I haven't met, I'm Morgan Ronimus. This September, I will celebrate 15 years with Mulcahy Law Firm. So now you can put a face to the name. A lot of you I've worked with over the years on collecting delinquent assessments for your associations. And behind the scenes, one of my other roles here is to make sure these classes and virtual events go off without a hitch. I work closely with Beth on all of it. So if you've ever dropped a question in the chat, there's a good chance I'm the one who responded. Before we get going, we've just launched a couple of quick polls. Go ahead and answer those, and we'll look at the results together in just a minute. Today's session is going to be presented by our Associate Attorney, Haidyn DiLorenzo. Beth and Haidyn have spent the last couple of weeks putting this class together, and I think you're going to get a lot out of it. Before I turn things over to Haidyn, let's get a few quick housekeeping items out of the way. Questions for today's session were to be submitted to our firm by 5 p.m. yesterday. If you submit one today on Zoom or in the Facebook comments, we'll carry it over to our live virtual First Friday event in September. This allows us to stay focused on our topic, which is how to effectively manage enforcement and violations in community associations. Based on the questions Beth received at our live virtual First Friday event this month, when she answered 55 questions, it is very clear that enforcement is a major concern for boards right now. Okay, before we dive in, let's take a look at those poll results and learn a little about who's in our audience today. We've got attendees from communities all over the Valley. Knowing your role and where you're joining from helps us keep these programs as useful as we can. So first, what city do you reside in? Avondale, 2%. Chandler, 17%, Glendale, 2%, Goodyear, 3%, Mesa, 30%, Peoria, 5%, Phoenix, 7%, Scottsdale, good showing, 20%, Surprise, 9%, and Tempe, 3%. Now the second question is, let us know your current role. 67% of you are on the board of directors, 9% community managers, 20% interested homeowners, and 4% other. Thank you everyone for responding. It's always helpful to see who's in the room and the different perspectives we've got. All right, I'm very happy to introduce Haidyn DiLorenzo. Haidyn joined Mulcahy Law Firm in 2021 as an associate attorney. She's an Arizona native, and she earned both her undergraduate degree and law degree from Arizona State University. Outside the office, Haidyn is a reader. She does Pilates, she goes to concerts, and she spends time with family and friends. She's also a lifelong learner with a real interest in philosophy, theology, and human behavior. And on a personal note, Haidyn is one of the kindest teammates I've ever had the privilege of working with. She's thoughtful, she's incredibly knowledgeable, and she brings a clear, practical approach to everything she does. It is a privilege to work with Haidyn every day. Haidyn, we're excited to have you lead today's class. I will turn it over to you.
Well, thank you, Morgan. And a big thank you to Morgan, Alexis, Beth, and everyone else behind the scenes who put so much time and effort into making these classes happen. There's a lot that goes into preparing each program, from coordinating the event to gathering questions, and of course, making sure we're covering the issues boards and managers are dealing with every day. So I really appreciate all the work that goes into it. I'm very happy to be with all of you here today, and I think we have a timely and practical topic to cover. So our topic today is how to effectively manage enforcement and violations in an HOA and condominium association. Enforcement is one of those areas where boards and managers can face the most day-to-day challenges. When it's handled consistently, fairly, and in accordance with the law and your governing documents, it helps protect property values and preserve the character of the community. But when enforcement is unclear, inconsistent, or reactive, It can create conflict, frustration, and potential legal risk for everyone involved. So without further ado, here's what we're going to cover in today's class. We'll start with why enforcement matters. So why enforce at all? What does Arizona law expect from boards? And why does consistent enforcement matter in your association? We'll then move on to building a defensible enforcement process. So we'll discuss notice, opportunity to be heard, hearings, documentation, and due process. Then we'll move on to common violation categories and some examples for you. So we'll talk about architectural issues, parking, landscaping, nuisance concerns, short-term rentals, and other common violations that we see. Next, we will move on to fines and avoiding selective enforcement. So we'll discuss when fines are allowed, how to structure those fines, and how to avoid arbitrary enforcement. Following that, we will discuss handling difficult owners and repeat offenders. And we will give you some practical communication tools, hearing strategies, and we will talk about managing conflict in your association. After that, we'll talk a little bit about fair housing and assistance animals. So we'll give you some guidance from HUD, some reasonable accommodations, some information on reasonable accommodations. We'll talk about emotional support animals and some enforcement pitfalls that we see in our area of practice. And we will finish up with a Q&A, so I will answer your questions and we'll talk about some real-world scenarios. So our goal today is to give you a roadmap so your board or management team can handle violations in a way that's fair, consistent, and defensible if it is ever challenged by an owner or in court or by a government agency. I'll also reference a few of our Mulcahy Law Firm cheat sheets during the presentation, especially our Enforcement of Governing Documents and People Problems Difficult Owners resources, so you know what you can download and share with your boards after class. Okay, so let's go ahead and start with the big picture, why enforcement matters. As you know, most communities have governing documents consisting of CC&Rs, bylaws, and rules that address matters such as architectural changes, landscaping and property maintenance, parking, vehicles, noise and nuisance, things like pets, and things like rentals or short-term rentals. These documents are essentially a contract among the owners and the association. When owners buy into the community, they agree to follow these restrictions. So from a legal perspective, the board has a duty to enforce those restrictions based on their CC&Rs and Arizona statutes. From a more practical perspective, consistent enforcement helps to protect property values. It maintains a consistent appearance and standard within your community. It reduces neighbor versus neighbor conflicts because the board and not individual owners handle the enforcement. And it builds trust that rules are applied fairly within your community. On the other hand, when enforcement is inconsistent or arbitrary, we often see claims of selective enforcement, allegations of discrimination, increased conflicts and complaints from homeowners, and sometimes even lawsuits or administrative complaints against the association. So we want to avoid that, so we'll give you some tips and tricks today to help you with your enforcement in your community. So to start things off, let me give you a quick story that really illustrates why selective enforcement is such a problem. So years ago, Beth had an association with a fairly common CC&R provision. So the provision stated, owners may place reasonable decorative items on the front porch, but items must be neat, in good condition, and not create clutter or a nuisance. So this is very standard language, and obviously it's very flexible as well. Well, one board decided the real threat to their community was pink flamingos. They had an owner, we'll call him Flamingo Frank, who had a small flock of 3 pink flamingos in his front yard. Not 20, not a full tropical resort, just 3 flamingos that he enjoyed. So the board ended up sending multiple violation letters. They scheduled a hearing, and they also seriously discussed imposing fines against Flamingo Frank until the flamingos were removed. They were convinced the flamingos were clutter and not in keeping with the community's aesthetic. So here was the problem. As Beth walked the neighborhood, she saw a porch with a big seasonal wreath and a welcome friend sign, a porch with 2 large metal yard art pieces, a porch with a rustic bench and 3 potted plants, and a yard with a very enthusiastic holiday display, lights, inflatables, and a 10-foot snowman in December. So none of those owners had received a violation letter. Now imagine you're Flamingo Frank, sitting in a hearing and being told your 3 flamingos violate the no clutter rule. And meanwhile, 2 streets over, there's a 10-foot inflatable snowman and a metal sculpture that looks like modern art, and nobody seems to care. So you can probably guess what happened next in this scenario. Flamingo Frank claimed selective enforcement. He showed photos of some of those other homes with decorations, and he asked, why am I the only one being cited? He also suggested that the board didn't like his personal style and that they were targeting him personally for his style. So obviously, at that point, the board realized it had painted itself into a corner here. If it enforced the no clutter standard only against Flamingo Frank, it looked arbitrary and unfair. But if it suddenly enforced the rule against everyone, it risked a full-scale backlash from owners who had had porch decor for years in the community. So Beth used that as a teaching moment. If a rule uses flexible words like reasonable and clutter, the board needs a clear written standard for what that means in practice. If the board hasn't enforced a rule for a long time, it's also risky to suddenly enforce it against just one owner. And if you're going to enforce a rule, you need to plan to apply it consistently across the community, even when the decor is not your personal taste. In the end, the board took a step back, adopted a simple porch and yard decor policy with clear limits, such as height, number of items, and safety considerations, and started fresh with consistent enforcement. So the lesson for all of us in this is enforcement is not just about whether a rule exists. It's about whether the board is willing to enforce that rule the same way for everyone, even when it's inconvenient or unpopular. If the answer to that question is no, it's time to rethink either the rule or the approach before your association becomes as famous as the community that went to war with pink flamingos. So the theme for today is consistent, reasonable, and documented enforcement. All right, so before we move into the practical steps for building a defensible enforcement process, Morgan is going to help us with a quick audience poll.
Thank you, Haidyn. We'd like to get a sense of the enforcement issues that are most challenging for your association right now. What is your association's biggest enforcement headache right now is our poll question. Parking and vehicles, landscaping and exterior maintenance, noise, nuisance, or behavior, pets, including assistance animals, short-term rentals, or other. We'll give everyone just a moment to respond. While those come in, a bit of firm news. On November 1st, Mulcahy Law Firm will celebrate its 30th anniversary. So you can imagine the stories Beth has. My favorite thing around the office is when Beth starts a sentence with, back in the day, because you know it's going to be a good story. And if you're voting for parking here in the poll, make sure you ask Beth next time she's here to tell you her limo story. If you haven't heard it already, you're in for a real treat. All right, let's take a look at those poll results. 30% responded parking and vehicles. 37% responded landscaping and exterior maintenance. 6% noise, nuisance, or behavior. 2% pets, including assistance animals. And 8% responded with short-term rentals. 16% with other. Haidyn, I will turn it back over to you.
All right. Thanks, Morgan. Now, let's go ahead and talk about what a defensible enforcement process looks like. So a defensible process does 3 main things. Number 1, it follows your documents and Arizona law. Number 2, it gives owners notice and an opportunity to be heard. And 3, it It applies rules consistently and fairly. Now, beginning September 12th, 2026, there is an additional statutory reminder for both planned communities and condominiums. House Bill 4011 imposes a duty on associations to act reasonably when exercising discretionary powers. In practical terms, that means associations must exercise discretion neutrally, fairly, without favoritism, and in a non-arbitrary way. This isn't a completely new concept. It largely reflects the principles Arizona courts have already applied when reviewing board decisions and covenant enforcement. But it's an important reminder that a board can't enforce rules based on who the owner is, whether the board likes that owner, or whether a board member has a personal disagreement with that owner. So as we go through today's process, let's keep this standard in mind. Enforcement decisions should be grounded in the governing documents, supported by the facts, and applied consistently to similarly situated owners. Okay, so let's talk about step one. Step one is clarify what is enforceable. So the question you should be asking yourself is, what exactly are you enforcing? So to do this, we should be starting with the CC&Rs, or the declaration for your association, the bylaws, and the rules and regulations, architectural guidelines, and policies. Make sure the rule you're enforcing actually exists in one of those documents and has been properly adopted. So for example, if the CC&Rs and rules say no overnight street parking, you can enforce that. If the board has only talked about a rule informally, but never adopted it, the board needs to adopt the rule properly before enforcing it. All right, step two is providing notice to the owner. So Arizona law requires notice before an association takes enforcement action. Basic due process requires it too. That's especially true when fines or a hearing are on the table. So to begin, we start with the courtesy reminder letter. This is where most enforcement starts. The board or the management company will mail a courtesy letter or post a notice on the property. The letter will identify the violation and give the owner a set amount of time to fix the violation. And in most cases, that's the end of it. The owner usually takes care of the problem right away after receiving that kind of notice. If the violation isn't corrected in time, the next step is a formal violation letter. So that can come from the board, the management company, or the association's attorney. This letter puts the owner on notice that fines are coming. So here's why that matters under Arizona law. Before an association can impose a monetary penalty, the owner is entitled to two things: notice and an opportunity to be heard. The violation letter is the notice. The opportunity to be heard is the owner's written response or the owner showing up at a board meeting to discuss the violation. Once you've provided both, the board can impose reasonable monetary penalties for violations of the declaration, the bylaws, or the rules. So there's a couple of things that a good violation letter should have. So first, it should identify the specific violation. Second, it should cite the exact section of the CC&Rs or the rules that are in violation. Third, it should describe what needs to be done to correct the violation. Fourth, it should provide a deadline for compliance. And fifth, it should explain what will happen if the violation is not corrected, such as fines or a hearing. So here's an example. On July 1st, we observed your red pickup truck parked overnight on the street in violation of Section 6.3 of the CC&Rs, which prohibits overnight on-street parking. Please move the vehicle off the street and ensure that it is parked in your driveway or garage by July 10th. If the violation is not corrected by that date, the board may consider fines and additional enforcement action. Okay, so this next piece is one that people often miss, so stay with me. Under Arizona law, an owner has a right to push back when they receive a violation letter. Say the association sends a violation notice about the condition of the owner's property. The owner then has 21 calendar days to respond in writing via certified mail. If the owner does that, everything stops. The association can't move forward with any enforcement, so no fines, no self-help, no litigation. until the association writes back. And you have 10 business days to do this after you receive the certified response. So that written response to the owner must include 5 things. Number 1, the provision of the governing documents the owner allegedly violated. Number 2, the date of the violation or the date it was observed. Number 3, the first and last name of the person who observed it. So this actually has to be an actual name. It can't just be the community manager. 4, the process the owner has to follow to contest the notice. And 5, this following statement exactly word for word. You have the option to petition for an administrative hearing on this matter in the Arizona Department of Real Estate, pursuant to ARS 32-2199-01. That used to be handled by the Department of Fire, Building, and Life Safety. So if you're working off an older template, that's the language to update. Once you've sent all 5 items to the owner, the clock starts again, and the association can proceed with enforcement. Now, we will go ahead and get into step 3, which is providing the opportunity to be heard. If the violation continues, the board should schedule a hearing. For these hearings, you should provide written notice of the hearing date, time, and purpose. You should also offer the owner an opportunity to attend, explain their side, and present evidence. The board should take the opportunity to listen, ask clarifying questions, and also should be sure to avoid arguing if possible. After the hearing, the board has a couple of options. It can decide to give more time to comply. It can impose a fine consistent with the association's fine policy. It can suspend certain privileges if allowed by the governing documents. Or it could choose to refer serious or repeated matters to legal counsel. So at these hearings, we recommend documenting in the minutes who attended the hearing, what was discussed at the hearing, and what the board ultimately decided. So what happens if the violation still isn't fixed? At that point, there are really 2 options left. The first is self-help. So some governing documents give the association the option to go in and correct the violation themselves at the owner's expense when the owner won't take care of it. So that could be something like mowing an overgrown yard or removing something that shouldn't be there, or something like that. But here's the really important part. Self-help is only available if your documents actually authorize it. And if they do, they almost always spell out a specific procedure, including notice, timing, and sometimes a waiting period. Be sure to follow that procedure exactly before anyone sets foot on the property, because skipping a step is how a legitimate enforcement action turns into a trespass claim against the association. And then the second option is litigation. When nothing else will correct the violation, the association can file an equitable claim in superior court and ask for an injunction. In most cases, the judge orders the owner to stop doing something or to go do something affirmatively. And the association is typically awarded its attorney's fees and costs for having to bring the lawsuit. Now, because the lawsuit can be a time-consuming and expensive process, we usually do recommend using litigation as a last resort and proceeding with those prior steps that I provided to you before proceeding with litigation. Okay, so let's talk about step 4, which is consistency and documentation. So this is where HB 4011 becomes especially important. Beginning September 12, 2026, associations will have an express statutory duty to exercise discretionary powers neutrally, fairly, without favoritism, and in a non-arbitrary manner. 2 crucial habits help boards to meet that standard. Number 1, be consistent. Treat similar violations in a similar way. And number 2, document everything. Keep copies of letters, photos, emails, notes of conversations you may have had, any hearing materials, and any board decisions that are made on the matter. Consistency doesn't mean every situation has to have the exact same outcome. Facts can be different. But if the board treats two similar situations differently, it should be able to clearly explain the legitimate documented reason for that difference. So this is exactly what our Enforcement of Governing Documents cheat sheet walks through, a step-by-step process with sample language and best practices. It also includes a simple form to log violations so boards and managers can track patterns and help ensure owners are treated similarly. So we definitely recommend that you check that out. Let's switch gears here and talk about some common violation categories and examples. So let's start with architectural and exterior maintenance violations, because these are some of the most common and most visible violations that we see in our area of practice. So I'll go ahead and give you an example. An owner paints their front door a bright color or adds decorative shutters without prior approval, even though the association has an approved color palette and requires architectural approval for exterior changes. So based on the framework we discussed earlier, the board's first step is to confirm there's a rule or CC&R provision requiring architectural approval and compliance with an approved color scheme. So once they've located that, the board should send a notice letter describing the unapproved change. For example, front door painted bright red outside the approved color palette, and cite the specific section of the documents that prohibit this. Along with the notice letter, the board should offer a hearing. In many cases, the board may allow the owner to submit a late architectural request. The board can also still decide whether to approve the change as is, whether to require the owner to repaint to an approved color, or to modify the shutters. Lastly, be sure to apply the same approach to other owners with similar issues so you're not singling anyone out. This avoids selective enforcement and why me arguments. Okay, let's move on to another example. So an extremely common issue is failure to paint or badly faded exteriors of homes. So in this example, the home's exterior paint is badly faded and peeling, and the trim is cracking. So let's walk through that process again. The first step is to confirm the CC&Rs or design guidelines require owners to keep homes in a neat, attractive, and well-maintained condition, or require repainting when paint is faded or peeling. The second step is to send a notice letter describing exactly what you're seeing. For example, faded stucco on the south and west elevations, peeling trim around the garage and front door, and cite the specific section of the CC&Rs or guidelines. The third step is to provide a reasonable timeframe for repainting. Painting, as we know, is not always a weekend project. So many boards will give 60 to 90 days, sometimes longer if the weather's an issue or if the owner's trying to line up a contractor. The fourth step is to offer a hearing. If the owner, disagrees, needs more time, or has special circumstances such as health or financial hardship, the board may want to consider those things in the hearing. And the fifth step, if there's still no progress, is that the board can consider fines consistent with its fine policy. In some cases, painting is also a good place to consider payment plans or staged deadlines, such as one elevation at a time, rather than just jumping straight to heavy penalties. So a key point to remember in all of this is to be specific, reasonable, and consistent. Don't simply say, your home looks bad. Say exactly what needs to be addressed and by when. Okay, let's move on to another example and talk a little bit about front yard maintenance, because dead grass and weeds can quickly spread and affect the whole street, as we know. So in this scenario, an owner's front yard is dead and full of weeds. So you're probably catching on by now, but the first step would be to locate the specific provision of the governing documents that addresses this issue. The second step is to send a notice letter citing the CC&R section that requires owners to maintain landscaping in a neat and attractive condition. The third step is to provide a reasonable timeframe, especially in the summer, perhaps 30 days for initial cleanup and a follow-up inspection. And then step 4, if there's no compliance, is to move to a hearing and potential fines following the association's written fine policy. So this is an area where the question of self-help sometimes can come up as well. So some Some CC&Rs contain a self-help clause, which allows the association to enter a lot, perform certain maintenance, and charge the owner for the cost after notice and an opportunity to cure. If your association has that type of clause, there are a couple things that you should remember. So first, don't jump to self-help as the first step. Start with those steps that we discussed previously, including notice, time to cure, and a hearing. We also recommend using self-help sparingly for clear, objective problems. So for example, a front yard full of knee-high weeds or a serious safety issue, such as an overgrown tree blocking a stop sign, would be good opportunities to exercise self-help. We also recommend following the exact procedure in the CC&Rs, including the notice, deadline, any board decision, and documentation of costs that are required by the CC&Rs. Be consistent as well. If you use self-help for yard maintenance, have a board policy so you're not entering some yards and ignoring others. Lastly, if you or the association's agent performing the work are confronted by the owner while engaging in self-help, it's best to leave and reevaluate the situation. Safety should be the number one priority in these situations. In that same vein, it's usually not a good idea to use self-help for painting or major structural work. Those projects are expensive, invasive, and in our experience, much more likely to result in disputes over color, quality, or timing. So for painting, it's almost always better to work through the notice, hearing, and fine process, and then offer reasonable deadlines or payment plans for the painting, and use legal remedies only when absolutely necessary. For architectural and exterior maintenance violations, the pattern looks more like making sure the rule exists, giving clear notice and a reasonable timeline, offering a hearing, and then using fines and, in limited cases, self-help, always in a consistent and documented way. Okay, let's move on to another example that we see often in our area of practice. I would say that parking is often the number one complaint that we receive, but enforcement authority depends first on who owns the street. So, an example for you. In this planned community, overnight street parking is strictly prohibited. So, for street parking violations, our framework is going to look a little bit different. So the first step in these kinds of violations is to determine whether the street is publicly or privately owned. So if the street is owned by the city or the county, the first step is to confirm whether the association has authority to regulate the roadway under ARS Section 33-1818. Under this statute, post-2014 planned communities generally cannot regulate government-owned roadways after declarant control. Pre-2015 communities retain their existing authority only if the required membership vote passed by June 30th, 2025, and the association recorded confirmation of that authority. If it lacks authority, refer parking violations to the appropriate governmental entity or law enforcement agency. The association generally should not tow a vehicle from a public street. The statute does not apply to privately owned roadways or one-way streets. So if the street is association-owned or privately owned, our process would look like reviewing the CC&Rs, parking policy, and towing policy. After that, consider progressive enforcement. So issue a warning letter, impose fines, and potentially towing the vehicle only when authorized and appropriate, and always after careful legal review. Before towing from private property, confirm compliance with applicable signage, authorization, any towing contract, and any local rate requirements under state and local law. And always apply the rules consistently and provide any required notice and opportunity to be heard to those owners. Okay, turning to nuisance violations. These are pretty common in associations. Nuisance violations can include things like repeated loud parties, barking dogs, or other behavior affecting neighbors. So it's really kind of a catch-all category. I'll give you a scenario regarding a nuisance. So a homeowner has regular late-night parties and neighbors are complaining. So what do we do in this situation? Well, the first step would be to encourage neighbors to document dates and times, and when appropriate, involve local law enforcement if there are any serious disturbances. After you gather that documentation, we recommend sending a violation letter referencing the nuisance clause of your association's governing documents. Almost all CC&Rs have some form of nuisance provision. And then lastly, offer a hearing and consider progressive discipline if the behavior continues. Okay, and moving on to another violation that we see all the time in our area of practice, and that is short-term rentals. Now, in this scenario, an owner advertises the home on a short-term rental platform in violation of the CC&Rs. So what do we do here? The first step would be, again, to confirm the CC&Rs actually restrict short-term rentals. So oftentimes, CC&Rs may have some vague language that may look like a restriction on rentals or short-term rentals, but we do want some more concrete language that kind of explicitly restricts those short-term rentals before issuing a violation letter. So if once that's established, we recommend documenting the listing with screenshots and then sending a violation letter citing the specific restriction. If the owner continues to offer the property on the short-term rental platform, consider fines, and in serious cases, consider legal action or turning the file over to your association's legal counsel. Our firm has separate cheat sheets and classes on short-term rentals, so if your main issue is short-term rentals, I highly encourage you to download those resources from our website. Okay, switching gears here a little, let's talk about fines and how to avoid selective enforcement. So a couple of best practices for you. As far as a fine policy should be written and adopted by the board, reasonable in amount, and consistent in how it's applied. Most associations use some kind of progressive fine schedule. That could look something like a first violation will receive a written warning with no fine, a second violation may be a $25 or $50 fine, and then third and subsequent violations may be in escalating amounts. Fines are generally a very effective method of getting owners to correct their violations. However, in some cases, enforcement may need to be escalated to the association's attorney. Now, if an owner refuses to pay their fines, associations can enforce payment in a couple of different ways. So first, by turning the file over to an attorney for further enforcement and collection efforts. In rare cases, filing a lawsuit against the owner, obtaining a judgment, and recording the judgment with the county recorder's office. After that judgment is recorded, the association will have a lien that's effective upon conveyance or paid at the time of the sale of the lot or the unit. Additionally, associations may proceed with collection of the judgment through traditional collection means, such as a bank, wage, or rent garnishment. Associations no longer have the right to record a notice of lien for unpaid fines and penalties, interest, late charges on fines, and other fees and charges. So that's just something to take note of. And a couple of important points to note. First, always verify what the governing documents and statutes allow. Second, keep fines proportional to the violation. So, a first-time weed violation probably isn't worth $100 a day. So just keep it proportional. And then make sure owners have notice and an opportunity to be heard before imposing those fines. So how can we avoid selective enforcement in our associations? So a selective enforcement occurs when the board enforces a rule against some owners but not others, or the board enforces more strictly against certain people. So for example, if the board fines one owner for parking on the street, but ignores 3 others doing the same thing, that's obviously a big red flag. If the board enforces landscaping rules only against certain homes while ignoring obvious violations next door, that's also a problem, right? So to avoid selective enforcement, we recommend using a violation log and regular community inspections. We also recommend applying the same steps to all owners. And if the board decides to stop enforcing a particular rule, it should do so openly and consistently. The board should also consider consulting legal counsel and formally amending or rescinding the rule when appropriate. Arizona courts and statutes expect boards to act in a reasonable, neutral, and non-arbitrary way, and that is now also reflected in the new statutory duty to act reasonably that we discussed earlier. Now, as a final note, we recommend that associations adopt an enforcement policy and notify residents of this policy. The policy should outline the steps the association will take to address a violation, such as reminder notices, demand letters, fines and penalties, self-help, referral to an attorney, corrective action, filing a lawsuit, or anything like that, as well as any fines which may or shall result in response to a continuing violation. So associations should also consider placing reminders in the association's newsletters or mailing notice to the owners regarding common violations, such as parking violations, and request that all owners comply by a certain date. Okay, let's turn to handling difficult owners and repeat offenders. So as we know, enforcement is really about people. So let's talk a little bit about how people impact this kind of enforcement. So as I'm sure everyone listening is aware, there are some owners who either don't read the community documents or they don't understand the rules, or there are some that simply don't want to comply. Others may be anxious, defensive, or angry when they receive a violation letter. So in these circumstances, we have a couple of practical tips. So tip 1 is to focus on the behavior, not the personality of the owner. So instead of saying, "You're a bad neighbor," say, "The dog barking after 10 p.m. is impacting your neighbors. Our rules require pets not to create a nuisance." So this framing provides the owner with notice of the behavior to correct, and it's less likely to result in defensiveness. Okay, tip number 2 is to keep communication professional and calm. So we recommend using neutral professional language in letters and emails. And we definitely recommend avoiding emotional language, making accusations, or using sarcasm in these serious conversations. Instead, we would recommend stating the facts, citing the rule, and explaining the next steps thoroughly. Now, tip number 3 is use the hearing as a conversation. So at hearings involving violations, listen first. So we recommend asking questions like, "Can you tell us what's going on?" Or "Is there something we should know about your situation?" Sometimes owners have things like health issues, financial hardships, or other circumstances that the board can reasonably consider while still enforcing the rules. And then tip number 4 is to set boundaries. If an owner is repeatedly hostile, harassing, or abusive, establish communication boundaries. For example, require that all communication be in writing. Also, consider adopting a board owner conduct policy. And in extreme cases, consult legal counsel about letters addressing harassment or threats. Our firm's People Problems, Difficult and Disgruntled Owners cheat sheet has practical scripts and strategies for dealing with difficult owners, including when it's appropriate to involve law enforcement or legal counsel. And as a reminder, if there's actually a scenario where the board fears for safety, law enforcement should be contacted as a first step. Okay, switching gears here, let's talk a little bit about fair housing and assistance animals. So I want to spend a little bit of time on this because it's an area where enforcement can easily go wrong if boards aren't careful. So let's start with the basic fair housing framework. Under federal and state fair housing laws, associations may not discriminate based on protected classes. And these classes are disability, race, color, religion, sex, familial status, or national origin. For today's topic, we're focusing on disability because that's the basis usually used for assistance animals, including emotional support animals. So the Department of Housing and Urban Development, or HUD, has issued guidance on how housing providers, including HOAs and condos, should handle requests for assistance animals including emotional support animals. So from HUD's perspective, an assistance animal is not a pet. Assistance animals include both service animals and emotional support animals. And associations must make a reasonable accommodation to their rules to allow an assistance animal when certain criteria are met. This means rules such as no pets, no dogs over 25 pounds, or no pets in the building may need to be modified for a disabled person with a qualifying assistance animal. So HUD's guidance outlines a step-by-step process for housing providers when they're faced with a request for a reasonable accommodation. So the first question that your board should be asking is, does the person have an observable disability? So obviously some disabilities are more observable than others. So if the disability is not observable, did the person provide reliable documentation from a healthcare or mental health provider showing that they have a disability and need an assistance animal? So one that we see pretty frequently is somebody with diagnosed anxiety. Obviously, that's a difficult one to observe out in the open, but if the owner does receive a letter from a healthcare or mental health provider showing that they have this, then they will qualify for or as having a disability. Now, the next question to ask is there a nexus between the disability and the assistance the animal provides? So in other words, what's the relation between the disability and the assistance animal that is being requested? And if all of these questions are answered, then the association should grant the reasonable accommodation unless it poses an undue burden or direct threat to the association. So this is pretty important. HUD warns against automatically rejecting documentation. So online letters can be more closely scrutinized, but they're not automatically invalid. Associations should consider whether the provider is legitimate, has a provider-patient relationship, and actually evaluated the person. Okay, let's look at some examples of how this plays out in the day-to-day. So in this first example, a condominium has a no pets rule. An owner submits a letter from a licensed therapist stating that the owner has an anxiety-related disability and needs an emotional support dog. Under HUD's guidance, the association generally should grant the accommodation and allow the dog, even though pets are otherwise prohibited. So, as a reminder, the association may not charge a pet fee or pet deposit for the assistance animal. And they also may not treat the assistance animal as a violation of the no pets rule. However, the association can require the owner to clean up after the animal and enforce nuisance rules, such as rules against excessive barking or aggressive behavior. Okay, let's look at another example. So in this example, an HOA has a rule: dogs must weigh under 25 pounds. An owner with a disability asks to keep a 60-pound dog as an emotional support animal. So based on those steps provided above, the association should evaluate the request as a reasonable accommodation request. The fact that the dog exceeds the weight limit doesn't automatically justify denial if the HUD criteria are met. Okay, so I have a couple of emotional support animal do's and don'ts. So first in our do list is do treat emotional support animal requests as disability accommodation requests, not merely pet exceptions. Do also use a consistent process for evaluating documentation. Do keep paperwork confidential and limited to decision makers, as this is often dealing with some sensitive information. And do enforce behavior rules, such as no nuisance or aggressive animals, the same way for all animals, including emotional support animals. Now, when it comes to our do nots, do not automatically deny a request because the animal exceeds a weight limit. Do not demand overly invasive medical records from the owner. Do not charge pet deposits or pet rent for assistance animals. And lastly, do not ignore HUD guidance, which is what HUD and fair housing agencies will use to evaluate any complaints that they receive. So it's very important that we follow these guidelines. Now, this is an area where it's very helpful for boards and managers to consult with legal counsel before denying or heavily restricting an emotional support animal request. A mishandled emotional support animal matter can quickly become a fair housing complaint. If you're interested, our firm can provide a fair housing and assistance animal checklist that boards and managers can use to walk through the HUD factors and document their decisions. All right, as we get close to the end of our class today, let me go ahead and recap the main takeaways for you. So first, we talked about enforcement and enforcing your documents consistently and legally. So we discussed using your governing documents in Arizona law as the roadmap and following a clear written enforcement process. We then talked about giving notice and an opportunity to be heard. We talked about sending clear violation letters, conducting fair hearings, and documenting the board's decisions. After that, we discussed using fines carefully and consistently. So that means maintaining a written fine policy, using progressive and reasonable fines, and avoiding selective enforcement. Then we moved on to being professional with difficult owners. We discussed focusing on behavior, not personality, using calm and neutral communication, and setting boundaries when needed. And lastly, as we just discussed, respecting fair housing laws and HUD guidance. So treating assistance animals as accommodations, evaluating documentation carefully, and enforcing behavior rules consistently. Our cheat sheets, enforcement of governing documents, board meeting basics, people, problems, and difficult owners, and our fair housing materials are designed to help you put these concepts into practice step by step. And that is going to go ahead and bring us to the end of the formal presentation for class number 8. Thank you all so much for your attention today and for the work you do as board members, managers, and community volunteers. Enforcement, as we know, is genuinely one of the hardest parts of running an association, and we hope today gave you some practical tools and hopefully a little more confidence in that process. So we'll go ahead and shift gears now to the Q&A portion of the class. Morgan's going to come back and take us through those questions, and I'll do my best to answer them for you. So Morgan, back to you.
Thank you, Haidyn. Wow, that was a lot of ground to cover. You made it look easy. So way to go.
Thank you.
All right, everybody, let's move on to the question and answers. Quick reminder on how this will work today. For this session, we asked that questions be pre-submitted by 5 o'clock yesterday. So those are the ones we'll be reading. Anything we don't get to today will roll over to our September live virtual First Friday event. And thank you all again for joining us for class number 8 of the 2026 virtual HOA Condo Academy. All right, Haidyn, here is our first question.
Let's do it.
This question comes from a resident in a builder-controlled community. Our HOA is still controlled by the builder. Residents are not allowed to attend board meetings except for the annual meeting. We also do not receive meeting minutes or information about the board's decisions. Does Arizona law apply to a builder-controlled association?
Yeah, so good question. In my opinion, a declarant-controlled board should follow Arizona law, including Arizona's open meeting laws. A developer-controlled board should also hold meetings and keep meeting minutes, just like a normal board. In my experience, however, developers often don't do either of these things. The law is somewhat gray in Arizona on this, and developers may take the position that they're not required to hold those open meetings like association boards. So that's just something to be aware of and to be prepared for. But ultimately, failing to keep minutes is not a best practice, although it's also rarely challenged. Our firm can go ahead and also share a cheat sheet with you, and this one is from developer to homeowner control, and that provides a little more information on what that transition looks like.
Thank you. Here is the next question. This question comes from an owner. My question is about monthly assessments and late fees. The payment coupon and management website do not say when a payment becomes late. The CC&R say assessments must be paid within 30 days. If I make the payment sometime during the month it is due, can the association still charge a late fee?
Yeah, so if the association's CC&Rs require assessments to be paid within 30 days, the association shouldn't be charging a late fee until the 31st day. So the late fees shouldn't be incurred until after that 30-day period.
Thank you, Haidyn. Our next question comes from a board member. If a homeowner is behind on assessments, can the association remove the owner from insurance, policy or refuse to pay a claim?
So the answer to that is no. The association does not have a legal right to remove the owner from the insurance policy or to refuse to pay a claim. An owner's delinquency doesn't allow the association to remove that owner from the coverage. But if an owner owes assessments, the association should just go ahead and follow its collection policy. So that may include things like sending a demand letter, recording a lien, or if the amounts remain unpaid, they could always file a breach of contract or foreclosure lawsuit.
All right, our next question is from a community manager. What is the process when an owner requests a hearing and the board needs to make a decision? Since the board cannot vote in executive session, can the hearing take place there? And if the association uses a hearing committee instead of the board, do the same rules apply? Can the committee make a decision during the hearing?
Yeah, that's an interesting question. So the hearing may take place in executive session or during the open portion of a board meeting. However, pursuant to that new guidance from the Court of Appeals, the board can't vote in executive session anymore. So any vote would need to be held in the open portion of the meeting. Now, something to note is that if the owner asks for the hearing to be held in an open meeting, Arizona law requires the board to move the hearing to the open portion of the meeting. And in that case, the board could both hear the hearing and also render a decision in the open portion of the meeting. Now, if the association uses a hearing committee, it's our firm's opinion that the committee should make its decision in an open meeting as a best practice. That's true even if the committee is not the board itself, or if it's not made up entirely of board members.
Thank you. Our next question comes from a board member. Our community is in the middle of major renovations. After requesting receipts, I saw what appeared to be a lot of wasted money, and I have lost a lot of confidence in our management company. First, can I, as an owner, require an independent audit? Second, if the board says no, can I hire my own accountant to do one?
Yeah, good question. So an individual owner generally can't require the association to obtain an independent audit. That is ultimately a board decision, but an owner can hire an accountant at the owner's own expense to review the records and review, the documentation that owner is entitled to inspect. So Arizona law requires the board to provide an annual audit, review, or compilation, and the board decides which of those options to obtain. Now, those are very different levels of work, obviously. An audit is going to be the most thorough, and a compilation generally presents the financial information in an organized format without independently verifying it. So a compilation can still satisfy the statutory requirement. Now, one important exception is the association's governing documents. So if your CC&Rs or bylaws require an annual CPA audit, then the association is required to obtain one. If you have concerns, you could ask the board in writing to place the issue on a meeting agenda, and that would create a record in the minutes. And I would also recommend checking the governing documents for a petition right, because some communities allow a certain percentage of owners to request an audit. Budget season can also be a good time to raise that issue. So you could ask the board to approve a full audit for the renovation year, particularly if you frame it as protecting the project and the association's funds. Now, an owner may hire an accountant at the owner's expense, and you have the right to inspect association financial records, and you're also allowed to designate someone in writing to inspect those records for you. Now, in this kind of scenario, the accountant would step into your shoes, so they would only be able to inspect the records that you are entitled to inspect as a homeowner. So the accountant can't compel interviews, it can't require access beyond those records, and it can't conduct an audit on behalf of the association. Additionally, it's important to remember that some records will remain confidential. So that'll be things like attorney-client communications, any pending litigation materials, anything like executive session, meeting minutes, and personal information of other owners. The management company's internal business records are generally not association records either, so it's likely that they wouldn't be able to request those. Now, if you believe money is actually missing, that may be more than just an audit issue. The association may need to involve its attorney at that point, and it might want to review any applicable fidelity coverage and consider whether a forensic accountant is appropriate at that time. So for a renovation project like you mentioned, receipts may not tell the full story. So I would ask to review the construction contract, and then any change orders or competing bids, any reserve study that was done, and the project budget. So those documents are often more useful in determining how the project was approved and managed.
Thank you, Haidyn. Our next question comes from an owner. Our board does not provide meeting minutes, hold annual meetings, or share the budget. The association used to have a management company, but the board decided to hire a property manager and an accountant without informing the owners. It has been more than a year, and there is still very little communication from the board. What options do homeowners have?
Well, first of all, I'm sorry to hear that. That sounds like a difficult situation. And it sounds also like the board may not be following required corporate procedures, and the management company may not be giving the board appropriate guidance and advice on this. So in these situations, homeowners do have several options. Number one, they can become involved themselves by running for the board. And additionally, there is potential to be able to remove board members by following the process in Arizona law and the association's governing documents if your board is very unresponsive and not responding to your concerns. Now, other options may include sending a formal sending just a formal letter through an attorney. There's also an option to file a petition with the ADRE if the association isn't complying with applicable law or its governing documents. And then in some situations, if it gets really bad, there's a possibility of filing a lawsuit. So the appropriate option will depend on the specific facts in your situation. And it's also going to depend largely on your governing documents and the association's history. But homeowners aren't without remedies in these situations. So there are some things that you can do if you find yourself stuck like this.
Thank you. We have a few additional questions related to enforcement. Can a community use self-help to correct a landscaping violation?
Okay, so I think we touched on this quite a bit in the class today, but in short, they can only do this if the CC&Rs expressly authorize them to do so. So before using self-help, again, the board should also make sure it's followed any required procedures that may be included in the CC&Rs, including things like providing advance notice when required by the CC&Rs.
Thank you. Okay, the next question. When can an association begin imposing fines for an ongoing violation?
Okay, so pursuant to Arizona law, the association can impose monetary fines only after providing the owner with written notice and an opportunity to be heard. However, associations should also be sure to follow any enforcement or fine policy they've adopted when it comes to imposing fines. So if you have a fine policy that says no fine will be imposed before an initial warning is given, then you should be sure to give that initial warning before any fines are imposed.
Great. Our next question comes from a board member. We have sent multiple violation notices, held a hearing, and imposed fines, but the owner still refuses to comply. What are the board's options?
Okay, so it may be tempting to jump to filing a lawsuit, but before that step, I would recommend that the board make sure that it's followed the governing documents and created a thorough enforcement record for this owner. So one useful step can be to have the association's attorney contact the owner in writing or over the phone and discuss the violation and possible resolutions. So oftentimes we do find that when our firm gets involved and we send a violation letter from us, that's 90% of the time all it takes to get an owner to comply. Now, depending on the circumstances, if you have a particularly difficult owner, The association may also consider filing a petition with the Arizona Department of Real Estate, which would potentially provide a lower cost option for dispute resolution between your association and that owner. Now, in really bad situations when the violation is ongoing and fines haven't brought the lot into compliance, the association may want to consider filing an injunctive relief lawsuit. An injunctive relief lawsuit basically just asks the court to enter an order requiring the owner to comply with the governing documents. And the association often receives its attorney's fees through that process as well. So that can be a good option if the association has incurred a lot of attorney's fees trying to get a violation corrected. In addition to that, the association can also seek a personal judgment for any unpaid fines when appropriate. So to kind of wrap that up, involving the association's attorney early can really help the board choose the correct avenue for their given situation.
Thank you, Haidyn. We have one final question, and it also touches on self-help. A problem owner has ignored the board's efforts to obtain compliance, and the violation is affecting the community. Can the association enter the property to correct the violation?
Okay, so this is back on the topic of self-help. And so ultimately, this is going to depend on the association's governing documents. So as we noted earlier in today's class, some declarations have a provision which authorize the board to exercise self-help, which can look like going into the property and correcting any kind of violation themselves, and then billing the cost of that work back to the owner who's in violation. Now, before exercising that authority, as I touched on earlier, the board should carefully review the scope of its rights in the CC&Rs and make sure that they're complying with any procedures that are required therein. Now, something to note is that in condo communities, the governing documents may authorize the board to enter a unit sometimes even without prior notice in some kind of limited emergency, like if there's a water leak that could lead to damage to neighboring units or common elements. Now, because improper entry can expose the association to liability, the board should really be consulting legal counsel before exercising a right of self-help, but especially in these situations where they're trying to go into a unit without providing prior notice. So just to help you stay on track and make sure you're not getting into any legal binds, we recommend contacting counsel.
Great, Haidyn. That's all the questions for today. So great job, Haidyn.
Thanks, Morgan.
Okay, thank you everyone for being here today. I know that I saw a couple questions roll into the Q&A session Q&A chat on Zoom. If there's a particular cheat sheet you're looking for, or you need some additional guidance or need help finding it, please email our firm at info@mulcahylawfirm.com, and we will have a team member provide you with the cheat sheet you're looking for. Otherwise, check out our website at www.mulcahylawfirm.com. All right. Thank you to everyone who has joined us today. We hope you found this class helpful, and we appreciate everything that you do for your communities. Truly, it is a thankless job. As we head into September, we'll kick off Labor Day weekend, often considered the unofficial end of summer, with our live virtual First Friday event. Please join us on Friday, September 4th from 9 a.m. to 10 a.m. You can attend live on Facebook or through Zoom. If you asked a question during this class, it will be answered during September's First Friday session, so you won't want to miss that. We are also happy to share Beth will be back for First Fridays, and she'll also be here for next month's virtual HOA Condo Academy class. Our next Academy class will take place on September 15th at 11 a.m. You can join us on Zoom or Facebook. The topic is Associations Records, Transparency, and Disclosures in the Digital Age. And also, we will definitely be talking about the new laws that go into effect next month, because those new laws become effective on September the 12th. So in addition to the new laws, we'll discuss the records an association must maintain, how long those records should be kept, and how to respond to owners' records requests. We'll also cover which records may legally be withheld and how to protect confidential information while meeting transparency requirements. Finally, we'll discuss disclosure obligations, transfer fees, capital contribution fees, and common mistakes that can create unnecessary liability. Thank you again for joining us today. Enjoy the rest of August and stay cool, everybody. We'll see you soon. Bye-bye.